Okay, thank you, everybody. Tom, you want to walk us through the rewrite of originating bill number 4?
Certainly, Mr. Chairman. Originating bill number 4 that the committee has before it would amend Article 7 of Chapter 61 and add thereto a new section designated Section 3A. The purpose of this bill is to prohibit persons who are already prohibited from possessing firearms from possessing concealed non-firearm deadly weapons. And the penalty, first offense, would be a misdemeanor with a fine of $100 to $1,000, 90 days to a year, or both. Second and subsequent offenses would be a felony and with a fine of $1,000 to $5,000, or a definite term of years of not more than 5, or both incarceration and fine.
All right, we're open for questions of council. Senator from Harrison, you have a question for council?
Thank you, Mr. Chairman. Yes, Tom, thank you. I finally understand the purpose of this bill. I was having a hard time with it. Let me ask you this, just kind of tangentially. Can now with constitutional carry, can we carry any concealed weapon? I mean, is there still a penalty for carrying some other form of concealed weapon?
I think there's a question about the enforceability of it as to other types of weapons because of the inclusion historically of firearm under deadly weapon, because in Section 61.7.2 they list a number of weapons, including firearms. And in previous rewrites dealing with concealed carry and constitutional carry, the water has been muddied.
I would think so, but just to be clear, if you're permitted to constitutionally carry a firearm, then you cannot run afoul of this statute, correct?
Would you repeat the question?
Sure. If you're not a person prohibited to constitutionally carry concealed, then you can't run afoul of this bill we're trying to pass. In other words,
I believe the senator to be correct.
Okay, that was my concern. Thank you.
Senator from Wood County.
Thanks, Mr. Chairman. Council, if you could just refresh my memory on what prohibits an individual from carrying a firearm. I know a felony is one.
And it depends on jurisdictions. Here, if you're a convicted felon, you're prohibited both federally and by state law. If you have been convicted of domestic violence, battery, or assault, you're prohibited. West Virginia law has a broader definition of family member than the feds, but they both prohibit people convicted of domestic violence misdemeanors. And then if you're under a domestic violence protective order,
is mental illness included in that?
If you've been adjudicated, yes, sir.
Okay.
And there's some others, aren't there? There's habitually addicted.
Habitual addiction.
Habitual alcoholism. Illegal alien.
Illegal, yes, sir, I believe you're right. I can just read them real quick.
That's okay. I just wanted to get a general idea of it. So with this new section of code, we're saying that those individuals can't carry what?
It references, and I'll refer the senator to Section 2 of Article 7, which lists the following: blackjacks, gravity knives, switchblades, nunchucks, brass knuckles.
So if you're not under this prohibited group, you can carry the weapons you just listed without a permit now?
Well, I think that's part of the problem, Senator, is some confusion in the law that this is designed to clear up. So under the bill, you could, if you were not federally prescribed, you could carry those things concealed. Yes, sir.
Okay, you could carry any of those lists, like the ones we went over on Friday. You can carry any of those without a permit.
Yes, sir. Under this bill, for
Okay.
sure. And that's what I believe the purpose of the bill is, to clear up some ambiguity.
Okay. Okay, thank you. Thank you, Mr. Chairman.
Thank you. Senator from Upshur.
Thank you, Mr. Chair. You know, Tom, this is interesting because I just read an article, I don't know, a couple of days ago. California's got they're not really called a SWAT team, but it's kind of like a SWAT team. Of course, California is radically anti-gun and everything. So they've got these guys whose job it is to go around the state of California knocking on people's doors who they have reason to believe might have a gun, who, because of a conviction or a judicial order and so on, would be prohibited from having the gun, because California's got even essentially a registration system. So the most common response they get from, they knock on someone's door to say, hey, we're here because we think you might have a gun and you're prohibited from having a gun. The most common response they get is, I didn't realize that I'd done something that prohibited me from having a gun, because they have a whole list of misdemeanors, which we have. You can have a judge, issue an order based on some type of restraining order or something, and that's something that they mentioned in there. Sometimes it was literally a result of a judicial order that the person couldn't possibly have had any prior knowledge of, and yet here comes essentially a SWAT team knocking on your door to come in and take away all your guns. In that particular case, you could see how that creates a bit of an issue. And even the guys whose job it is to go around and do this say there's a lot of people on this list that really we don't understand why they'd be here either, because we all like the Second Amendment and everything. Now what we're doing here is creating a whole new group of people who may or may not be aware of the fact that for one reason or another they're prohibited from carrying a firearm, and as such they're also now prohibited from carrying a pocket knife. So is that really what we're going to do, is play a game of getcha?
I beg your pardon? I'm sorry.
I mean, it seems like that's what we're doing, is playing a game of getcha, just sort of, they didn't even know they were breaking the law, but we're going to get them anyway.
Well, and I believe I'm safe in saying that's not the intent of the bill.
Well, I'm not saying it's the intent of the bill, I'm saying it's the effect of the bill. You just named off at least one item there that, it's another one of those things, almost like having a firearm that has, some scary attributes about it, so then we call it an assault weapon. A switchblade, for example. I've got a switchblade. I've carried it since I was a kid off and on. It's great if you're going to be climbing on a ladder and you need to have a hand free that you can use to cut stuff with. Well, having a blade that you can hit a button and the blade snaps out and locks open is great, but hardly makes me a criminal to have it. There might be other stuff that people would assume does, but not that, surely. And yet, with this provision, if somehow, somewhere along the way, I was prohibited from carrying a firearm, I might still be carrying that without realizing that I'm committing a crime to carry that.
Well, and the senator's correct. Under the language in the proposed originating bill, that factually would be correct. Yes, sir.
Okay. Thanks, Tom.
Senator from Logan.
Thank you, Mr. Chairman. Tom, my biggest thing here is when you say felon, I mean, there's a lot of crimes out there that label people as felons that aren't violent felons. And, a lot of those people out there that are trying to get their life back on track and are actually working, a lot of working class citizens out here carry multi-tools and things like that. So that's one of my biggest fears right here. I mean, initially when I heard about this, it was carrying pocket knives, and where I'm from, everybody over the age of 6 will find themselves in trouble if that's the case. But now that we narrow it down to felons, I still have to say that, there's a lot of people out there that in their job, pretty much requires them to carry things like knives and stuff like that. And I think, putting them in a situation that could derail them and put them back in jail is not a good thing.
And again, that would be a policy matter for the body.
Other questions of our council? If not, we're open for discussion or amendments. Senator from Upshur.
Thank you, Mr. Chairman. I just thought we might want to see if there's anybody in the audience here that wanted to speak to this.
Senator from Upshur County asks unanimous consent that members of the public or the groups who are here today who wish to address this legislation be allowed to address the committee. Is there objection? Chair hears none. Whom did you have in mind? Senator from Upshur?
Well, I do see members of the WVCDL are here. I don't know if one of them would want to speak to it. I think we have people here from represent municipalities.
All right. Well, I'll see.
There's a lot of people here.
Okay. Well, we'll certainly be delighted to hear from them. Keith, come forward. For our listeners and viewers and committee members, Keith, would you state your full name, please?
Keith Morgan.
And you are here on behalf of?
I'm here on behalf of the West Virginia Citizens Defense League.
All right, Keith, I need to ask you, raise your right hand. You swear affirm the testimony you're about to give the committee will be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Morgan, welcome back to Senate Judiciary. We're delighted to have you here with us. Senator from Upshur.
Thank you, Mr. Chairman. Keith, if you could maybe just kind of give us your perspective, your organization's perspective.
Well, the initial originating bill, quite frankly, was effectively a repeal of about half of the constitutional carry provisions this legislature has passed over the past couple of years. The latest version that I have seen is not quite so severe. Senator Ojeda's commentary about this affecting felons, based on the language that I've seen, that is the scope of the effect of what is there. So this is a far different animal than what was kind of floating around the past day or so. The WVCDL is our position on it. The way it reads now is pretty much neutral, because we do not see it as affecting our membership. We generally, to my knowledge, have no felons within our membership. So as of right now, the way it stands, we really have no position on it.
Thank you. I didn't have any
Other questions for our guests? Did you have a follow-up question, Senator from Upshur? Senator from Logan?
Thank you, Mr. Chairman. Well, what is your thoughts on if we were to possibly amend this and just list violent felons? Because once again, I mean, my thing is I know a lot of guys out there that are labeled felons that aren't violent, and they work construction jobs and things like that. And the multi-tool that's another hand.
Well, we're certainly getting into some very broad policy questions here. I think that there is some danger. I brought up recently the notion that a carpenter's tool belt is filled with an awful lot of things that could be called and are called in code deadly weapons. And I think there tends to be some will of the community out there. We've heard all this second chance stuff for folks that are coming out of prison trying to get their lives back together. Under this bill, if a carpenter throws a coat over his tool belt, he could potentially find himself afoul of the law. Now, do we think it would be enforced that way? We don't know, but that problem could potentially happen.
You have Senator from Logan have a further question or no? Senator from Jefferson have a question for our guest.
Yes, thank you, Mr. Chairman. Thank you for being here. It's the enforcement that has me concerned the most, because essentially we are asking our police officers to be watching out for these felons, for these people, to see if they're carrying anything. And although, again, I'm not in favor of encouraging people who have been convicted of violent crimes, like the senator from Logan was mentioning, having deadly weapons among them. One of the things that, when we had the whole discussion about constitutional carry, is that the criminals are not going to be obeying any laws we have. And it's the law-abiding folks who are the ones that really are affected by the decisions that we make. And that's one of the things that worries me, is how this is going to be able to be enforceable. And again, not every knife I would consider, a potential weapon, although anything could be used as a weapon. A pen could hurt somebody if used in a certain way. So I just worry about that, and I don't know if you have looked at the consequences.
It is, our definition of concealed deadly weapons is actually extraordinarily broad in that it goes through and explicitly lists basically the set of an 80s gang movie in terms of, nunchucks and throwing stars and things like that. But at the bottom of the list, it basically, and I'm paraphrasing, says anything that could be used as to cause grave physical harm is a deadly weapon. So presumably, I could do something pretty awful with this light here. It's a deadly weapon. If I hide it, I could be a foul of the law if I'm a felon under this measure.
Yes, and again, I don't know. I would feel more comfortable if there was an intent somewhere in here versus just making it, if you're just happen to be carrying something and you have been ever convicted of any kind of crime that prohibits you from having a firearm, you can no longer have a Swiss Army knife, for example, or something like that.
On general principle, Senator, I would agree with an intent. I tend to think in general in matters of criminal law that intent should be a factor, except in very rare cases.
Well, thank you very much. I appreciate your thoughts.
Senator from Wood County, have a question for our guest.
For council, as soon as Mr. Morgan's done.
Are there any other members of the committee have a question for Mr. Morgan? If not, Keith, thank you very much for your appearance here today and for the information you've shared with our committee. We'll look forward to having you back. Tom, yes. Senator from Wood.
Thank you, Mr. Chairman. I'm just curious, in a practical sense, Council, how this would work if a felon goes into Lowe's and buys a knife. What's stopping him?
Well, nothing would be stopped. This only deals with carrying them concealed, so you could carry one.
Okay, so you can buy one, you just can't cover it up, just like a okay, I misunderstood. Okay, thank you. Thank you, sir.
Thank you. Senator from Jefferson.
Thank you, Mr. Chairman. I was wondering, you started listing the types of folks who would be prohibited. We mentioned felons, those convicted of domestic violence or assault, have a protective order against them. Habitual addiction, I had never heard that one before. Is that something that is actually somebody who's been convicted in a court of being habitually addicted to a substance?
No, ma'am, it's a fact question, frankly. And that tracks federal law pretty much, which preceded it. The state had the federal government had a firearms prohibition long before West Virginia did, and for consistency purposes, I believe the state has pretty much tracked that over the years.
Do you happen to know the definition? What is a habitual addicted person? I just had never heard of that one before.
And I don't know it is defined. I think it really is a fact question.
Okay, so if someone is considered to have a habitual addiction, do they necessarily know that they are considered, like if they're not convicted, if there's no court that has told them you're a habitual offender of addiction, abuse, or you will no longer be able to carry a concealed weapon because of that? I mean, is there any time in which that person would know that they are now under this?
Well, with regard to firearms, that's been the law a long time.
Yes.
With regard to what's in this bill, it'd be an education process.
But I'm just wondering, like, how does one know that they qualify?
Well, you're presumed to know, we're all presumed to know the law. And I'd say from the standpoint of firearms, it's pretty well established. The knowledge is out there. And with this, it would have to be an education process.
Okay. You know, one of the things I've learned through being in this committee is that it's important that things are defined and clearly understood, especially if we're going to be charging people with misdemeanors or felonies. So it just kind of concerns me a little bit. Thank you, Tom.
Senator from Wetzel County, have a question.
Thank you, Mr. Chairman. Tom, basically, what I want to ask you is, what will this law accomplish?
I believe the point of it is to thinking of dangerous weapons generally, and including things other than firearms in it. It's council's understanding that the purpose of this, as it comes before the committee, is to keep people who have been determined shouldn't be allowed to possess firearms, to possess other kinds of deadly weapons in a concealed manner.
Do you feel if I'm going to go commit a violent crime, do you think I'm going to worry about this law? This would be the least of my worries.
I understand, Senator.
So what I'm just trying to say is, what are we going to accomplish by passing this law?
Well, I think council is assuming that the thinking is that through an education process and otherwise, it would get the message to people who are prescribed from possessing firearms that they can't possess other deadly weapons concealed either. And that'd be it. And then as an enforcement mechanism, if they did it, they'd be subject to arrest.
Now, does this says the article from possessing? So, in other words, if I have a real nice kitchen knife in my home and I'm a felon, am I going to be subject to arrest under this law?
No, sir. Only if you're carrying it in public in a concealed fashion.
Well, the weapon says possessing. Oh, federal.
It's possessing the firearm, which is a general prescription. And what the originating bill says
concealed,
is if you're prohibited from possessing a firearm by federal or state law, you can't carry these weapons concealed. And by definition, it's in a public place.
Well, I'm just
you're fine in your house.
Trying to think what's going to accomplish by this law. That's my only question. Thank you.
Sure.
Senator from Tucker County.
Thank you, Mr. Chairman. Tom, so what you're saying is if I'm a felon and I can walk down the street with a 8-inch hunting knife strapped to my side, as long as it's in view, I'm not breaking the law, correct?
The senator's correct.
But if I have a 2-inch pocket knife in my pocket, then I am breaking the law. Or 3-inch, whatever. 3.5 inches? 3.5 inches, okay.
You could, yes, sir, you could be.
And if I'm carrying a hammer and it's on my tool belt and everybody can see it, then I'm all right. But if I cover it up with my jacket, then I could be in danger of being. Another question: a felon can't possess a firearm, but a lot of them hunts with bows, crossbows, and even muzzleloader. If they get caught carrying their bow in a bow case, couldn't that be interpreted as concealed of a deadly weapon also?
May I have 1 second, please? I would say no, and I would base that on the definition of concealed in 6172, Senator. Because it's, and I'll read that if you like.
You don't have to read it. So it wouldn't be considered a concealed deadly weapon?
If we're in a case, I do not believe so under this definition.
Go ahead, please, and read it. What is the definition of concealed in that other section?
Certainly, Mr. Chairman. Concealed means hidden from ordinary observation so as to prevent disclosure or recognition, A deadly weapon is concealed when it is carried on or about the person in such a manner that another person in the ordinary course of events would not be placed on notice that the deadly weapon was being carried. For purposes of concealed handgun licensees, a licensee shall be deemed to be carrying on or about his or her person while in or on a motor vehicle if the firearm is located in the storage area in or on the motor vehicle.
Okay. Other questions of council? Senator from Upshur.
Thank you, Mr. Chair. So, Tom, I think if I heard what you said there, the reason why that wouldn't be considered concealed is because the assumption is that the case would reveal the contents.
Well,
by the
yes,
nature
sir.
of the case. I mean, you got this, bow-shaped case. We assume you're carrying a bow. If you got a violin case, you're carrying a Tommy gun. Yeah. So that's what you're saying, right?
Yeah.
In other words,
sir, that is what I'm saying.
If that felon carries his bow into the woods in a 31 bags bag, that wouldn't reveal what was inside of it. That would be different, wouldn't it?
I'm sorry, I don't know what kind of bag that is.
Well, it's just it's a nondescript bag.
Candidly, I don't believe that's the intent of the definition of concealed. It really is, and all this that I'm familiar with, is carrying it on one's person.
So we would say that before we did constitutional carry, if someone were carrying, as opposed to say 31 bag, the normal shopping bag that someone might carry around, because it's not on their person, that was illegal before we did constitutional carry, to carry a firearm in a shopping bag with you everywhere you went.
Prior to the passage of constitutional carry, in order to have done that, you probably would have had to have a concealed.
Okay. So how is this a different standard, I guess, is my point. For example, a woman's purse is not carried on her necessarily. I mean, it's not. In fact, some women's purses are bigger than shopping bags. So are you saying that they couldn't have carried it in their purse before we did constitutional carry, but if they carried a sizable knife in their purse, what would be the circumstance here?
If the person were carrying it prior to the passage of constitutional carry, to carry it around in your purse, you would have been violating the law unless you had a concealed carry permit.
But if they carry a pocket knife in that same purse now, and they happen to be prohibited, maybe, as the senator from Logan pointed out, could have been a white collar felony, 20 years ago. They embezzled money and they've straightened their life out, but now they're carrying this knife in their purse. Would they run afoul of this?
Yes, I believe they would.
And so the question that the senator from Tucker raised is, if they're carrying such a crossbow in a case that clearly defines what it is, they wouldn't be guilty of carrying a concealed weapon. But if they were carrying it in a bag that did not clearly define what it was, they might well be guilty.
I agree, yes.
And that would be true whether we're talking about a crossbow or perhaps it's somebody who traps. And trappers a lot of times carry a deadly weapon for the express purpose of dispatching what they catch whenever they sometimes find that they've caught something alive. It used to be you couldn't even carry a gun to do it. You actually had to carry a club or something along those lines. Now, a trapper who, in his bag, a lot of times they'll have a bag that they carry on their back, like a backpack. It's got traps in it and various scents and baits and things like that in it. And they also drop in there a club or a small axe or something. Now they're carrying a concealed weapon, aren't they?
Could be. Now, I would note that the statute with regard, because you all have mentioned knives a number of times, and the statute says a pocket knife with a blade 3.5 inches long or less, a hunting or fishing knife carried for hunting, fishing, sports, or other recreational uses, or a knife designed for use as a tool or household implement shall not be included within the definition of knife as defined here unless such knife is knowingly used or intended to be used to produce serious bodily injury or death.
But again, the lamp there, if it were properly concealed. And again, coming back to my point, I know this from being a kid and trapping in West Virginia. A lot of people carry around a club with the express purpose of that club, especially before you were allowed to carry a gun. You carried that club. Sometimes you'd come out, maybe you caught a raccoon or something, and you smack it on the head to kill it with your club, right? Or some people actually carried around a little axe to do the same thing with. Use the blunt side of the axe to kill an animal, but then you can use the sharp side of the axe to cut stuff when you're in the woods, that's relative to setting the trap. And so they would be guilty because there's not an exemption for that, right?
I would think that. I'm sorry. Are we talking about the axe or a knife?
In this case, I'd be talking about an axe or a club, something clearly that they might be carrying. Heck, they might even know they're not allowed to carry a gun, but now, thanks to this, they don't know they're not allowed to carry their axe while they're out trapping.
Well, remember, it's got to be concealed. If you're carrying it in your hand or over your shoulder.
No, what I'm saying is from experience, I know you have this bag, you're carrying it on your back. It might have a dozen traps in it. You might have stakes in that bag. You may have your little axe in the bag. It's concealed. No one could see what was in your bag. It's essentially like a backpack, except instead of having a lot of pockets, it's usually just a great big open bag.
I would say that while certainly an axe can be used as a deadly weapon.
Have you seen The Shining?
I'm sorry?
The Shining? I think that.
Yes, I'm with you. I don't believe under the hypothetical that you gave that the person would have a problem.
We say definitely not, or you don't think? Or
I never say definitely not here.
Well, the problem with not being able to say definitely not is not saying definitely not here means that somebody out there may pay a price that's not the intent of this committee.
And the senator's correct there.
So we find people running afoul of the law. This is really a concern I have with this whole thing, is people running afoul of this law without having any prior knowledge and really any practical way of knowing that what you're doing is now become a strong misdemeanor, or if you're not careful, you wind up in a felony situation, and all because of something that we don't really seem to have any good idea why we even want to do this. I'm good for now. Thanks, Tom.
Under its general authority, the chair hereby removes originating bill number 4 from the agenda of this committee to receive no further consideration today. Let's move on.